Okay.
So again, I'd really like to make sure that this is functional and useful for you. So, if I'm getting too far into the weeds, please let me know. But I'm planning to give you kind of an overview today of some hot topics in bankruptcy, and in particular, highlight some of the recent expansions that we've seen in the different bankruptcy relief options that are available to debtors, starting with a really brief kind of overview mention of the Family Farmer Relief Act that has expanded availability of bankruptcy options for agribusiness, and then talk about the Small Business Reorganization Act, which is very new and also has been affected by a recent legislation with built into the CARES Act as well. So before we get into that, I'm going to just give you a little primer of the different types of bankruptcy relief that is out there, so you kind of have a context here. Even if you had very limited exposure to bankruptcy, most people have heard of the different bankruptcy chapters thrown around, Chapter 7, Chapter 11. Those are simply referencing different chapters in the Bankruptcy Code, which is a massive code book that's about that thick, that sets out the law that controls in bankruptcy cases. The most kind of commonly referred to bankruptcy setup is a Chapter 7, which is a liquidation form of bankruptcy. Big picture, there are two really different types of bankruptcy. The first, again, is a liquidation. What that really means, practically speaking, is a debtor comes to the court hat in hand, can't pay their debts, and they surrender all their non-exempt assets for sale. So a court-appointed trustee will liquidate the non-exempt assets and then distribute any sale proceeds to creditors. That could be, for example, a landlord. In your context, also could be someone who has a secured debt on real estate. One important thing to note generally in all forms of bankruptcy with respect to real estate lending is that a secured creditor will retain its lien on collateral. So when you're talking about relative security or insecurity of a creditor in bankruptcy, how much risk that they are facing, the one huge question is really how much is their collateral worth, and do they have guarantors that would cover them in the event that the debtor is unable to pay, or the asset isn't going to cover the debt. So that's of a liquidation type chapter. For individuals, you said that you have tenants, for example, or a real estate kind of management. If a tenant filed for bankruptcy, there would be an automatic stay, this regardless of chapter, an automatic stay that would pop into place that would stop creditors from being able to collect against them, take collection action. So it's important to know when folks that you're working with have filed for bankruptcy, to understand what actions are allowed and not allowed. So for example, if there's a past due debt when someone filed for bankruptcy, you couldn't then continue to send letters seeking payment of that debt once they're in a Chapter 7 or Chapter 11, really any chapter that applies. So then another general form of bankruptcy relief is a reorganization bankruptcy. And that is, really all of the other major chapters here are reorganization chapters. What that practically means is the debtor comes to the court and proposes a repayment plan. The repayment plan usually for individuals will be between 3 and 5 years. For businesses or for farms, agribusiness in a Chapter 11 or 12, that could be a much longer plan. And then more recently, we have this new flavor of Chapter 11 that's specific to small businesses. Their plans will be between 3 and 5 years, and I'll talk about that a little bit more in a bit. But basically, the concept here is instead of liquidating assets and trying to maximize the recovery for creditors in a reorganization, there are payments made by the debtor over a period of time, and those payments are distributed to creditors, either by the debtor in a larger Chapter 11 or by a court-appointed trustee in either a Chapter 13 individual reorganization or a Chapter 11 small business reorganization. And frankly, actually, in Chapter 12 too, there's also a trustee that helps administer plans. So after that duration of that plan, if the debtor is successful, they'll get a discharge of their majority of debts. This is really kind of boiling it down and speaking with some generalities here, because there are a list of debts or types of debts that are non-dischargeable in bankruptcy. For example, you probably heard of student loan debts, for example, can't discharge those. If you've run over somebody with a car and injured them, that's generally not dischargeable, especially if you were drunk while you did it. So there, and generally in the business context, we usually are looking more at things like fraud, to determine if there's maybe a non-dischargeability issue. But the idea is at the end of the day, regardless of whether you're in a Chapter 7 or a Chapter 11 or 13, the debtor's looking for what's called a discharge of debts. That means that there's a court injunction that stops creditors from collecting that debt in the future after the case is closed, and protects the individual or the business. That's the kind of fresh start you hear about sometimes. That's a real broad overview. Now, just noting on the Family Farmer Relief Act, this is a relatively new, it's not a new thing. It's a well-established chapter. It's Chapter 12 of the Bankruptcy Code. This is probably just relevant for you if you have any, like winery customers, people who have fruit producers, orchards, other agricultural related businesses. Christmas tree farms are big in Oregon. What we've seen as far as recent trends is a significant change in the average farm size since the 80s, larger businesses gobbling up smaller family farms. And what that's resulted in is just massive farm debt to a level that we've not seen since the 80s. Even just since 2013, we've seen an increase of 30% in farm debt. That's continued to increase in 2019 and also 2020, though I don't have a great number for 2020 yet since we're still in it, but that really has been an upswing. So we've seen pretty significant increase in farm-related filings. In response to that, last year, and this became effective in August of last year, we're still just seeing the tick up from it. Congress really substantially increased the debt limits, meaning that they really opened the door for agricultural related businesses to be able to get bankruptcy relief under Chapter 11. Chapter 11 is a particularly debtor-friendly chapter, which means there's a lot of protections built in. And it's just something to note, because if you do have, if you get a notice of a bankruptcy and it has anything related to an agricultural business, or you see Chapter 12, just know that there are additional protections in place to protect that particular debtor. And so, it's something where you're going to want to really evaluate next steps and how to approach any debts, including that could be from real estate lending to leasing. Really, with the Chapter 11s, there's a lot of equipment leasing. Probably not your specialty or your area, but there's just a lot that goes into it. But also there can be long-term farm leasing too. So moving on to kind of the meat of, I think, what might be somewhat more useful for you to know about is recent trends with Chapter 11 reorganization cases for small businesses. This is the Small Business Reorganization Act. It was passed last year, but did not come into effect until earlier this year. The real purpose of this was to make sure that small businesses were able to reorganize and efficiently, basically rehabilitate their businesses and actually survive a Chapter 11 and come out the other end and still be a functioning business. Kind of the why is this new option added? I think it's useful to look at what the trends were leading up to 2020, or to where we're at today, and that really, we were really seeing a high failure rate in small business cases in Chapter 11. It frankly just wasn't that well set up to deal with the particular struggles that small businesses face. Unfortunately, when small businesses hit a financial rough patch or something happens, often their finances can be in somewhat disarray, not as sophisticated as large businesses, and can kind of get underwater really quickly. They also, can't necessarily fund a Chapter 11 bankruptcy. There's a lot of potential expense that goes into it. It really is, or can be, a complicated and lengthy legal process. And so we were seeing a lot of failure there. And because of it, there was just a steep decline in the Chapter 11 filings that these small business debtors were actually, even giving it a shot. At the same time, I think might be interesting for you to know that Oregon had adopted a new receivership law, and Washington's expanded its receivership laws, and that's become more of a trend across the country too, with in particular real estate lenders and sometimes landlords with really long-term ground leases getting involved with trying to get a receiver appointed to manage a piece of real property while it's liquidated or dealt with in a state court process to avoid a bankruptcy proceeding because of the issues with time and expense. So that's been an option in particular for on the creditor lender side.
Do you want to explain to us what the Oregon receivership law major changes were real quickly, just for a second? Because Jamie and I will be getting involved in that over the next 6 months, I'm sure.
Yeah, so I could certainly do like an entire, frankly, an entire probably half an hour or hour on it, but I'll just say this. Oregon basically didn't really have a receivership statute in place until fairly recently, in the last year and a half, basically. And there was a work group that worked on it for a very long time. Initially, I'd say for, historically, we've had like a couple very short, a couple paragraph rules that allowed the courts to appoint a receiver. But there wasn't direction to the judges about, how far of a scope they should allow and what specific powers they should, grant to the receiver. And that led to a lot of problems, in particular with sale of real estate. Some judges, in particular in more rural counties, were very hesitant to allow receivers, for example, to sell real property. So, one of the changes was really expanding the details to make it very clear that receivers can, they can take on, if they want to, a very broad scope. They can also, frankly, limit their scope and exposure and narrow it as well. But the new statute, for example, enumerates the powers that the trustee has. It also puts in place some stay type protections to give a little bit of breathing room and limit what creditors can do while the receivership's getting up and running, and really a wide variety of other things. And so if you have any specific kind of questions about it, or is it something?
No, let me just summarize for everybody that so they know what a receivership is. For those that don't know, it's a time when a person, or actually a company, doesn't pay their bills, or like an office building may not pay its mortgage, and the creditor says, hey, I want to collect the rent directly, and they appoint a neutral third party, that's the receiver, to collect the rent, pay the bills, manage the property until the debtor and the creditor can figure out if they can get along or not. So I just wanted
Yeah.
to summarize that real quickly. And so those rules obviously seem to have been matured a little bit. So
Yeah.
haven't been a receiver more than once. I just was sort of curious. Okay, great.
Yeah, no, it's and that part is really interesting. I'll just say too, with receiverships, it can be really particularly helpful when you have like a specialized, type of real estate. Like if you had, leases or loans dealing with, say like a strip mall with a lot of tenants, needed to deal with management issues. I feel like you guys could be well positioned to help a receiver be, market properties in a receivership context, that sort of thing. So there's definitely opportunities there. Um, so
It's going to be interesting if this continues for much longer.
yeah, yeah, I think in particular we're going to see a lot of vacancies, and I'll get to that later. But a lot
Okay.
of vacancies. So just to give you kind of a brief overview here with respect to the Small Business Reorganization Act. Again, this is just for small businesses. Originally, Congress said it was basically meant businesses with less than 2.7 million in debts. They did exclude single asset real estate companies from the list, under the thought that basically if you're a single asset real estate company and you have 2.7 million in debt, you're not really small. But it's kind of arbitrary because you could have two pieces of property and still comply with that requirement. But basically, bottom line, it's for small businesses. Or just some kind of key to gloss over some key elements here. Like I mentioned, this really has streamlined the reorganization process to make it quite a bit easier for small businesses to get through a bankruptcy and survive. So they've changed things like they've limited the plan length to generally 3 years. It can be up to 5 if the court orders that. It allows for some expanded modification of certain types of real estate mortgages. Frankly, Chapter 11 allows a fair amount of flexibility for the modification of real estate loans. For example, for undersecured property, a debtor can, cram down, what it's called, basically reduce the amount they're paying to the equity in the property, and also modify the payment terms, extend out maturity, change in certain circumstances, change the interest rate. There's a lot of flexibility and power from the debtor side on what they can do with real estate loans. But with respect to this small business case, which is process, which is new this year, it's also expanded that somewhat with respect to residential mortgages. Generally, there's been greater restrictions on the types of modifications available when we're talking about residential mortgages. Usually, those are extremely limited. But here, if you basically have a mortgage that's not a purchase money mortgage, that is in connection with a business. So, for example, someone went out and owned a house free and clear, or maybe had a small original mortgage and then leveraged it with a big business loan, that can be modified in this new scenario. It also, the Congress also somewhat limited the amount that small businesses actually have to pay to creditors, and they're looking at a standard of paying net income over the life of the plan. This concept of net income is interesting because it's just not very, you really just don't have to pay very much necessarily. They let you pay all of your expenses to keep your business running, so before paying creditors, and then that what's left over is distributed over that 3 years. So this is big picture, more debtor friendly, worse for creditors. So there's also this really major hurdle that was eliminated for small debtors, and this gets pretty technical, so I'm just going to explain it in an example. In a standard Chapter 11 case, someone who is an owner of a company who files for Chapter 11 can't retain their ownership rights in that company unless unless either creditors are being paid in full, which frankly just never happens, or that individual comes to the court with a pretty significant additional contribution of resources to the business. So in a sense, they're almost buying back their ownership interest in the company. It's not unusual to see the court, accept, say, $100,000 to $300,000 from an owner of a company to basically be able to maintain their ownership value. And the the reason for that is because there's this general concept that the individual business owner shouldn't be benefiting when creditors are essentially getting the shaft, to say it bluntly. So the thing that has really just been a major cornerstone of this new small business case setup is the elimination of that rule that was traditionally called the absolute priority rule, and really it's giving priority to creditors over equity holders. And so we think that's going to make it a lot easier for companies that fit into this small debtor, under that small debtor umbrella, to be able to really get through a Chapter 11 and modify debts and reject leases and get through it unscathed and come out the other end, or partially scathed. I think everybody has a hard time in bankruptcy, but it's really trying to increase the success rate. So
can you take just a second and tell us a little more? Use the word reject leases. Can you tell us a little bit more what the reject leases means and how that plays in this framework?
Yes. So, and I'm going to just actually I'm going to just fast forward to this little slide on that. So I think that this is very key for folks that are dealing with leases and bankruptcy. And although this is true in both a Chapter 7 and a Chapter 11, it does come up more often in a Chapter 11, but it's kind of universal. So when you have a debtor in bankruptcy, we're talking about specifically a tenant that's filed for bankruptcy, they have two options for how to treat leases. They can either decide to continue performing under the lease, and if they want to continue on with the lease long term, they have to assume the lease. This is kind of a best case scenario for the landlord, and frankly for the tenant too, if it's a good location and they can continue to perform. This allows them to retain their lease rights. So generally this would come in the form of either the tenant filing a motion asking the court to allow them to assume the lease, or it would be in the Chapter 11 plan. And what it practically means is the debtor would stay in the location, that continue to perform, the lease terms would remain fully enforceable. The tenant may propose to assign the lease to a third party. Generally, that's still with landlord consent, though there can sometimes be fights over that depending on the terms of the lease. And when they do it, this is this shows that landlords have a huge, good, powerful lobby with Congress. Tenants have to cure their prior defaults. So an example would be, say you have a tenant that because of COVID-19 hasn't been able to pay for 3 months. And then you find out that they've filed for bankruptcy. Say it's a restaurant that is part of a larger conglomerate of companies that run similar restaurants, like Subway or Bamboo Sushi. Actually, is a good example.
Use Pizza Hut. Pizza
Yeah,
Hut.
Pizza Hut.
There we go. We have our tenant Pizza Hut who negotiated a new lease with us and then filed for bankruptcy.
Yes. So after they negotiate a new lease with you and they file for bankruptcy, the question is, okay, what's their intent and their treatment of that lease in the bankruptcy? Are they going to continue to perform? or are they going to and assume the lease and pay any defaults? Say they stopped after they renegotiated with you, there were some defaults and they stopped paying for a bit. And frankly, they often strategically do that in a lead up to bankruptcy because they're trying to retain cash flow for other things, and they can get away with it. So they'll do that. And then if best case scenario, they want to keep the lease, they have to pay back the defaulted amount and basically make you whole. There's just a delay with, basically legal process and timing of getting that payment. In order to reserve your rights to be paid in a bankruptcy, you do have to file what's called a proof of claim. That's a fairly straightforward form, but it outlines the debts that are owed, for example, under a lease in that context. The other option is rejection. So they can decide, we don't want to do this anymore. We're rejecting the lease. That's essentially a lease termination. There's actually a lot of litigation about what rejection means. It's not completely defined in the code, but I think that it's easiest and safest to kind of consider it essentially a lease termination. The problem with rejection, however, is it has really serious implications for the landlords. Let's talk just to contrast it. Let's talk about like a lease termination situation without a bankruptcy. So say your Pizza Hut client renegotiated that lease and then they just stopped paying. The landlord could sue in state court, deal with eviction to the extent that they were squatting on the property, for example, and then liquidate the debt that's remaining under the term of the lease and get a judgment in state court for that as damages, and could then take collection action to try to get paid. A landlord in that context does have an obligation to try to mitigate its damages. So you do have to make good faith attempts to get a new tenant in the space. And that's usually, kind of the only tenant argument in that state court scenario, where they're basically saying, we terminated, we gave you the keys back, we left it in broom clean condition. Now you have to go find another tenant, and you can't charge us for 20 years worth of rent because you got to get somebody else in there paying you. Well, I think that's going to get a lot harder here because especially with malls and strip malls, you're going to see a lot of vacancies. It's going to be a lot harder to get new tenants in those spaces, at least until the global pandemic and the economy calms down. So that's state court without bankruptcy. Contrasting that to a chapter, frankly, chapter 7 or chapter 11, where you have just a lease rejection in the bankruptcy context, the damages that a landlord can actually assert are capped, and it's a statutory cap. It's a really complicated calculation, so I won't get too far into it. I'll also tell you that not only is it complicated, but it's actually interpreted different ways depending on where the bankruptcy is filed. There's generally one interpretation over here, but I've seen recently, even with Oregon businesses, a lot of filings in Delaware and Texas and other locations, especially the big retailers and some of the restaurant folks as well. And so the actual amount of the damages kind of just depends, but rough back of the envelope kind of calculation or estimate in a lot of cases is 1 year worth of rent plus any actual physical damage that the tenant has made to the premises. So that could be very significant if you're talking about, say, a lease that has 7 years remaining and is in an area that's going to take 2 or 3 to actually get a replacement tenant if it's a really hard to lease location, and and things are just not doing well in the economy. Often this also means that the landlord's left with just an unsecured claim. I mean, they still have a landlord's lien on things that are in the left in the premises, but and you can for example, there's always the scenario where you lock the door and assert your landlord's lien over what's left. But as we all know, the stuff that's left in an office park or a Pizza Hut or whatever often isn't worth much of anything. So the landlord can have, in particular, a bankruptcy context and often an unsecured claim. And unsecured creditors are at the very bottom of the barrel in bankruptcy, often receive, pennies on the dollar. Frankly, if anything, there are quite a few bankruptcies where unsecured creditors receive nothing. In kind of that small business or even the standard Chapter 11 context, the standard is that unsecured creditors have to receive as much as they would receive if the debtor was in a Chapter 7 and liquidating. So you could kind of imagine, say Pizza Hut saying, well, if they're in a Chapter 12 and they're reorganizing, if they're going to look at the evaluation of what they'd pay their unsecured creditors, if everything they have is leveraged, if all of their real property has mortgages, loans, and their equipment has equipment lenders, and they have, say AR factoring financing that has a blanket lien on everything. Basically, if they liquidated, the unsecured creditors would get bupkis. So if you then go to the Chapter 11 scenario and they're looking at what they actually have to pay to meet this liquidation standard, it can be nothing. Usually they'll propose some small payment just to make sure that they meet that standard and get approved by the court. But unfortunately, landlords often get lumped in with the unsecured creditors in a lease rejection scenario. Does that make sense? Does anyone have any questions about lease assumption or rejection? Okay.
So you were talking about sort of exercising a landlord's lien and locking tenants out. And mostly that stuff isn't really worth anything anyway. But at what point can you actually do that? I mean, because if they file bankruptcy, you're really prevented from going after them for some term. At what point could you lock them out legally?
Yeah. So usually that is a scenario that we're looking at before a bankruptcy is filed. I certainly would not advise a landlord client after a bankruptcy is filed to lock the tenant out, especially if they're operating out of that premises. That would be very damaging, and it would violate the automatic stay, which is a protection that's put in place to assure that debtors aren't harassed by creditors during the course of a bankruptcy. It would actually also increase the risk for the landlord. Could be subject to having to pay the debtor's attorney's fees and damages and punitive damages. That gets really messy. So I really think primarily of the landlord lien enforcement kind of scenario as state court type remedy. Certainly we can assert a landlord's lien in the bankruptcy context, but we cannot do that by the lockout means. That's by asserting a claim by including that on the proof of claim, by dealing with it in say an objection to a plan, or basically raising it legally. Not that a lockout isn't legal, but not in a bankruptcy.
Yeah, no, that makes sense.
Yeah, and generally it isn't a remedy we use that frequently, but it does come up sometimes.
So is there a way for a landlord in the bankruptcy proceeding to say, you know what, we just soon do without this guy, throw him out?
To evict them essentially, or to terminate?
For the bankruptcy court to say, okay, we'll vacate that lease and you're on your own.
If the debtor really checks all the boxes and is successful in assuming the lease, then really there is not a way to do that. I mean, the best, if that was the objective, if the landlord's objective was let's toss out this tenant, or this is just a horrible scenario, we just don't want to do this anymore. Generally, the option is to just make sure that the tenant is absolutely performing every obligation under the lease, and that they pay all of the any prior amounts that are past due, and basically keep their nose squeaky clean. But if they're doing that and complying with the lease and complying with the bankruptcy code, unfortunately, there really is no way to get them out that I think it would be very successful. I mean, and wouldn't be very well received by a bankruptcy judge either.
So the upshot of it is the tenant can get the bankruptcy court to adjust the lease in their favor, but the landlord is entirely at the court's mercy when it comes to the short end of the stick.
Well, it's interesting. So the debtor does not get to actually, unlike a real estate loan, which can be modified, leases actually cannot be generally modified in a bankruptcy. So the landlord's perspective is just lease enforcement. So it's the only real kind of modification that you might think of in this bankruptcy context is a delay in accepting payment. But once that lease is assumed, they have to not only cure all the past due amounts that have to be paid under the lease, but they also have to then continue to perform under the lease. So for example, one scenario could be if there was a debtor that was in a long-term bankruptcy, still in, say, a reorganization phase, and had assumed a lease and then defaulted under the lease, there would be an opportunity in that scenario because of the default to terminate the lease. Because of the automatic stay, we may still have to go to the bankruptcy court and get permission to take action, but a tenant does have to perform under the lease even in a bankruptcy, and they can't really modify the terms. The only, again, the real modifications are for the kind of, it's the breathing room that the court gives the debtor is some delay in payment, but not changing the payment amount. And then also, the debtor may be able to assign the lease to another tenant, but there are protections that require landlord approval. Those approvals do have to be reasonable for that. So
what we end up seeing, what we've seen in several cases, is tenants who declare bankruptcy, and during that kind of initial period, that delay period, they hire a third-party company to contact all of their landlords and say, we're deciding which of our locations and which of our leases we're going to keep or reject. And if you don't want to be in the rejection pile, you're going to agree to our new terms now. Mm-hmm. And we've sometimes our clients will buy off on that, and sometimes they won't. But it's very awkward.
Yeah, no, it certainly is awkward, and it's not. I mean, really, what they're doing there is just using the unpalatable lease rejection option to leverage a new lease terms. And sometimes that is successful. Certainly, it really it's not so much a legal issue as just really a business decision. And I certainly have had clients who decide, I'd rather have someone in there now, paying $500 less a month than have to deal with trying to release a very hard to lease location, for example. So that certainly happens. And so that's that was kind of my main the main focus as far as leases and bankruptcy that I wanted to cover. If you're interested, I can and you're comfortable moving away from the bankruptcy topic, I can give you kind of an overview of some of the other tenant arguments that we've been seeing with COVID, if that's of interest.
Yes, please.
Okay.
Let's do it.
All right, so some common tenant arguments we're seeing. A frustration of performance is a big one that has been coming up. And basically this argument is that the tenant, actually even a landlord could use this depending on the circumstances, but usually it's coming from a tenant. They would say, we're not able to perform under this lease because of, circumstances stemming from the global pandemic. In particular, this can be a very compelling defense if the lease was relatively new, like entered into right before the pandemic hit. You could imagine, like, say you have a lease to a tenant that is going to have a massage clinic, and because of the governor's orders, could never open and actually, have a viable business in that location. In that type of scenario, this kind of frustration of performance defense has been used to negotiate basically a decision to unwind the lease or early lease termination without much in the way of penalty or, frankly, most of the time it's a buyout, a payment of a lump sum amount up front just to get out of a lease. We're also seeing a lot of folks argue about force majeure clauses or trying to argue about these. This is generally it's a similar argument, but it's a term that's baked into most leases, and it excuses performance when that performance is impossible due to circumstances outside the party's control. So, for example, terrorism, acts of war, acts of God, laws prohibiting certain actions. And it, with respect to the global pandemic, it's come up primarily with respect to governor shutdown orders. The one thing to note there is the vast majority of these provisions have a specific carve out for payment obligations, so they're not as helpful for tenants as many of the tenants want them to be. That said, it just kind of depends on the leases. I have actually seen 3 leases that had provisions of the many that I've reviewed since this started that were somewhat tenant friendly. One actually entirely excused performance of payment, and the other 2 kind of arguably could have. So it was worthwhile to make some deals in those scenarios. So those are 2 really common things. I'm seeing more this real trend with multiple location tenants that have an underperforming location and an effort to get out of a lease. And I think that in that scenario, most of the time tenants are trying to just work out deals, but it also does really open the door more to that bankruptcy option as well. And Marisol, if she's still with us, I have a limited number of people on my little screen. She has, she has dealt with quite a few lease type questions, and also, is prepared to, talk to you a bit about the moratoriums as well, and kind of how people are dealing with that and what we're expecting on that front too, if that's of interest.
Thanks, Margot.
Yeah.
First of all, Cliff, I didn't know that your company started in 1972. That was when I was born. So now I feel like a huge connection with your firm, and more than I did before. Great year. Yeah,
that was my father-in-law. My father-in-law founded the firm in '72.
That's awesome.
Yeah.
That
wouldn't make me very old, right?
You're very young.
Yeah, there we go. There you go. I want to be that young, yeah.
But yeah, we've worked together, and I just really appreciate you thinking of our firm. And I loved that we invited Margot to do this because she is wonderful. She is my partner, and also my partner in what we do a lot together in the real estate world. Just a tiny little background about me. I'm real estate lawyer for a long time. I actually started out doing condominium development with Paul Janik in the years when there was a lot of that, and then moved to this firm in the downturn, and I work a lot with lenders now, but I still have a huge plate of work for landlords and tenants, but a lot of retail tenants. And so interestingly, I thought with COVID that I would be getting lots and lots and lots of questions and help negotiating with landlords because of COVID, because I have so many retail tenant clients, and I have honestly just been dealing with people, which leads me to believe that there are a lot of great landlords out there who understand that they needed to step up and work with their tenants. And it also, I work with a lot of lenders, and I think even before all the legislation, my clients were calling me almost day one with what they could do on the loan end to help their borrowers. And I work with local, very small lenders, and I also work with big lenders, and they were all making those phone calls to me. So I think, like I said, I had some tenants though that were definitely asking me, what to do, and but some of, like I said, I only talked with a couple, but one of them was asking me for that help, and it was because the landlord, just because of their they were an investment company that had a lot of people up the chain that they had to get approval from. They just didn't have any flexibility, so I'm seeing like the smaller landlords that just understand and they're in the community, they're just being a lot more flexible than somebody that just has a lot of locations, is bigger, and has a lot more constituents that are looking down and having to get approval from. So that, to me, that seems like what the difference is.
Marisol, do you perceive that there's going to be a second wave of negotiations?
I
Because
do.
I know that Jamie and her team were busily working on a first wave of negotiations. I'm going to say April, May.
Yep.
And then everybody went, oh, it's not over yet.
Yep. Absolutely.
And
that's exactly
and my business hasn't come back. I was walking by a coffee store yesterday where they opened the doors at 8 o'clock, and there was nobody there.
Yeah.
Just nobody. People are not going.
Absolutely. And especially, I have one of my clients, the one that I've been working a lot with, she is in the ice cream business, and she has been like, her landlords are like, well, why aren't you trying to take this opportunity where people are, ordering things online, and, instead of just serving coffee there, why don't you do production? And it's like, her landlords are just not understanding like what it would take to actually, change your whole business model, So, she's had some luck again with landlords that are just more localized and like part of the community. So, but I absolutely think that there's, once this eviction moratorium is over, there's going to be the next round, because at this point with the bill that was enacted, the eviction moratorium, I think has given some breathing room to tenants to just be able to be like, okay, I don't have to try to like think about 300 things about how am I going to deal with this lease with my landlord breathing down my neck, because right now the landlord can't do anything unless they want to violate the eviction moratorium law. So I think, starting in October, when that ends, I think there's going to be more negotiation, but the eviction moratorium law also kind of gave to landlords, it's kind of forcing down their throat like what they're supposed to do, which is give a payment plan over 6 months. I mean, I don't know about you guys, but I don't see that things are going to go back to normal in October. So I expect that the legislature is going to jump back in.
Not in downtown Portland in any case.
Mm-mm. And so, one thing at the beginning of this, I told my couple tenant clients that I just can't see that the legislature can't step in here. I mean, it is, this is just so unprecedented, and the world is not normal. I mean,
Wait, hold on for a second. Jamie, your numbers today are 82% paying, correct?
That's awesome.
It's a bit higher than that. I think we're up to 86% of August rents collected at this point.
So Marisol, so you need to know that across the board, we're collecting just under 90% of our rents from our tenants. So that's renegotiated, right? Jamie, can you explain renegotiated to Marisol and to Margot?
We haven't had to give as many concessions lately. So our kind of revised numbers, we've collected like 87% of those. They're actually very close together at this point. Most of the concessions that ended up being given were in April and May and some in June. But at this point, mostly the people that are paying are kind of paying full freight again. And some of them are even starting to repay some of those balances.
And is that are these retail tenants?
So this is a mix. This is kind of all of our tenants across our whole portfolio, which is, about half retail and like 30% office, and some industrial, and some commercial owners associations. So
interesting.
But they're mostly kind of a mid-size level. We do definitely have tenants who are struggling and who are not paying. So there's definitely a subset of people who we've been having more issues with. But for the most part, everybody people are not really using the moratorium as a reason to just like stop paying and hoard all their cash. Mostly they're trying to keep up with things to the best of their ability.
That's awesome.
Which has been pretty remarkable. But
I mean, that statistic is really surprising to me, and also very comforting.
Yeah. I do think it shows how well you're doing as well, because I don't think everyone is having that experience.
No, and it does vary a lot. There are definitely clients who have been hit harder than others. There are buildings that have been hit harder than others. It's such a just kind of weird luck of the draw. Like, do the businesses in your building, are they able to maintain some functioning or not? And gyms are, I think, kind of the number one problem.
Absolutely.
Yeah.
Absolutely. As one of my lender clients has a gym in that situation, and but they're SBA loan, and so the SBA is making them try really hard to work with that client. So
yeah, and we've had a lot of tenants, like, I think a lot of our success over the past few months is because people have gotten the PPP loans and the SBA loans. And if that money starts to run out and business has not bounced back up enough, we're going to start seeing, I think, more problems coming.
That I totally agree with you. And like I said, our firm, we represent a lot of lenders, and one thing that I heard from one of my lender clients is that he has several businesses that told him as soon as they get their PPP loan forgiven, they are immediately going to do layoffs, because they don't want to threaten their ability to get the forgiveness. But as soon as that happens, they don't have the operations and the income to keep those people. So there's a lot of Band-Aids going on, and nationally and on the state level. And personally, I don't know how long that can last and how we can get through it. But I think you're right. I think the PPP loans have helped a lot. And there's other grants out there that some of my clients have applied for that have helped them through this period. So
Don't they have to spend them by the end of October, or when was it?
I'm sorry, I'm sorry, could you say that again?
When's the deadline for spending those funds? Isn't it?
Oh, the PPP loan funds? I think we've
We've passed it. We've
we've
already
passed
been
it,
past that.
yeah.
We're past the PPP loans. We were past it about a month ago. It was
So
the
now
end of
they're
July.
to get forgiveness. And so
Yeah, at this point, my lender clients are now, a lot of them have hired outside firms to help process the forgiveness applications. And they have to get approval from the SBA to start taking applications for forgiveness. So some of them have and some of them haven't. So, I'm not sure how long that process is going to take. But I did hear that many of them, those applications will go past the first date of the repayment if it doesn't get forgiven. So, which is around October. So probably they're not. I'm expecting a lot of the people in this state who got PPP loans will probably be under the. I'm expecting Congress to enact a just automatic forgiveness under 150. So I'm not sure, who your tenants are, but many of them will probably just get automatically forgiven for those loans. And then
Well,
for
at 1%, who cares? I mean,
yeah.
1%, you can do that for a long time.
Yeah, you can.
So, and pay it back. So it's not that big, but I have a feeling a lot of stuff is going to get forgiven. I just hope that that the next special session and the next Oregon legislature doesn't go back to force landlords to not get rent from tenants. At some point, tenants have to decide if they've got a business model that's survivable or not. And in this next phase of our economy, and one of the things that I believe, and I can't speak for everybody else, but we were right on the cusp of a recession anyway. And I'm sorry, that's my phone, and if I turn it off, then I get disconnected. So I apologize for it ringing. We're on the cusp of a recession. There were a lot of companies hanging on for dear life, and this just washed out a lot of non-performers as well. So the question is shouldn't landlords have the ability to have their property back so they can release it, even if it does take 24 months?
Yeah, I mean, and I'm totally in agreement on that because those landlords also have obligations to their lenders,
Absolutely.
And so I'm expecting at some point the Band-Aids are going to have to come off, and we're gonna see a lot more default situations.
I have a finicky technical question. So we've been very cautious about what we've been saying to our tenants because of the eviction moratorium and because it puts these very broad restrictions on threatening tenants with eviction. But it's not super clear about the time frame because there is, if they don't extend the date, you will be able to evict tenants for current month's rents starting in October. So can you say now to a tenant that this is coming and you will be evicted later if you don't perform, or is that a threat which is prohibited at this time?
Yeah, that's a good question. I'm not positive, but I will. I'll wrap my head around the eviction statute and let you know. I mean, as a lawyer, cautiously, you probably don't want to. I wouldn't advise that, but let me wrap my head around the statute for that specific question, and I'll email.
Yeah. I suspect the answer is that none of us really know the answer to that question until it gets litigated in a court at some future point. Because
I would say that I think you're probably safe to have a conversation with them about the future and raise it in, the non-threatening context of what are, now that we're getting closer to that date, what's the long-term plan here? But it is odd. I have heard mutterings. I expect that the date probably will be moved.
My summary, Jamie, says that during this emergency period, so until the end of September, The landlord may send a written notice to a tenant stating that the tenant continues to owe any rent due. However, the notice must include a statement that eviction for non-payment is not allowed before
Right.
September 30th. So it's kind of like
You can,
not necessarily that you can say that you can evict, but after that date, but during that time you can't. So it's kind of a backwards thing.
yeah.
Well, we don't want to get rid of any tenants. I mean, that's not our objective. Our objective is try to just help them think through the process so they can start planning on how they're going to pay their rent. Some business people are more sophisticated than others. So how much more do you have to cover, Marisol?
That was it. I was actually just going to do a summary of the foreclosure moratorium and eviction moratorium, but what I understand is you guys already know about that, so I was just going to open it up to questions.
Yeah, we did. We've done a lot of work on that, actually.
Okay.
HB 4213, yeah. We've spent a lot of time and energy. Both Jamie and I and the rest of the team have seen.
Yeah.
No, Stacy yesterday called me and she said, "What are you talking to about? HB 4213? Come on, Cliff. Rent?" So anyway,
yeah. Well, I mean, I've seen your summaries and they're great. So I just wanted to open it up because those are both. I work with lenders and with a lot of tenants and landlords, so my head is in those.
No, we're glad you are, and people need help, and they need a lot of help because this is a very confusing time.
Hey, Cliff.
Anybody have any questions?
Yeah, I do. Cliff?
Yes, Rick, go ahead.
Yeah, okay. We've been talking about commercial.
Uh-huh.
I'd like to know these ladies' position on apartment owner or apartment dwellers. It's a big difference when a Pizza Hut goes out of business rather than somebody standing on the street corner.
Marisol probably wants to be able to answer that, I have a feeling. Have you done any work on that, Marisol, at all? You haven't had any residential tenants reach out to you, have you?
I have not. No, the residential landlord tenant is an area that I don't get into because the statute is just so incredibly thick, and I don't like to hold myself out as an expert on it. So that's something I have punted off to other firms.
Right. No, I can tell you this, Rick, that both Alessia, Jim, and I have been working on some transactions throughout the state. And the biggest challenge right now with dealing with apartments, the biggest challenge right now is that, in fact, X%, anywhere from 30 to 20 to 10% of tenants are not paying rent on the basis of COVID. And they're claiming COVID. Now, it could be they've been laid off. It could be they have COVID in their family. It could be simply that they think they don't have to pay because there's a COVID environment. There's a lot of different people that have a lot of different attitudes about this. And so we have clients even that have 50% of their tenants haven't paid rent. And they can't force them to pay rent. I think the big challenge is going to be the same date. The rule that Marisol was talking about is date driven for both commercial and residential, which is end of September. And when the end of September comes, we will see which tenants are going to pay their rent in a payment plan format moving forward. We believe, on the residential side of our company, we believe that very few tenants who have not paid their rents will be able to pay their rent moving forward. We just don't think they can. And the people that have not paid their rent tend to be, Rick, the very poor. The people that just don't have other resources, and they're using this money to pay for their medical bills and the medicine and food and stuff like that. And they're hoping, I think, to seek shelter under personal bankruptcy from some of this indebtedness, which of course, they've got until March of next year to scurry around for. So, if that's what they decide to do. So, but at this point, middle income tenants are paying rent. Upper income tenants are buying homes. Lower income tenants, it's sort of a crapshoot on who's employed and who's not, and who's maybe ill and who's not. Just yesterday, I got a phone call from somebody who said their on-site manager, it's not one of our properties, is ill, and he refused to go to the hospital until he was so sick that he couldn't walk.
Wow.
So you know, this, you know, we're in a very strange time between deniers and non-deniers. And of course, this is in a county that is south of Portland. So there's a lot more non-deniability in that county. So yeah, it's a, Rick, I think that easily in many buildings, 7 to 10% of the tenants are not going to pay their rent on the basis of COVID and then figure it out. That being said, just for Marisol and Margot, the phone's ringing off the hook. We're renting units as fast as we can get them ready.
Interesting.
And that is just the weirdest, craziest, strangest thing.
That is really weird. And I want to tell you, I have, you know, I do a lot of loan transactions. I have 2 multi-family construction projects on my desk right now.
Well, I can tell you this, upper end, brand new construction, we can't get those rented for love or money. We're talking about the mid area, you know, $1,000 a month, $150 a month, you know, $1,050 a month. We can rent those every day, but you start getting in the $2,000 range for apartment unit, it's dicey. And we have some brand new projects close in division, 50th and division. It's taken us a year to fill up a 20-unit apartment building because we just keep reducing the rent, and there's 3-month rent-free giveaways because there's a bulge. It was a building boom in Portland.
Yeah.
So there's a lot of units, and so we have to get rid of that unit supply before we can either build more or before the rents and it all stabilizes. It's really more an issue of supply and demand, has nothing to do with COVID.
Yeah, absolutely.
I do think we will see an increase in bankruptcies that are driven by, you know, wanting relief from, you know, past due rent payments and mortgage payments. But this, I think, is going to be a curious environment, because what we saw with the mortgage crisis in, you know, 2008, 9, 10 was people staying in their houses as long as possible without paying their mortgages, you know, to basically have free
Rent, right?
place to live. I think it's just curious and interesting. I mean, and a lot of it may be, you know, unemployment or COVID related, but certainly some of it is not. And there will be, I think, a similar type of scenario that is open to renters for the very first time because of these moratoriums. And so there will be people trying to delay as long as possible before, you know, evictions can actually happen, and then we'll file. I can tell you that my debtor bankruptcy friends, I've done commercial debtor work, but I'm now really focused on the creditor, more transactional creditor side, and just contract lease enforcement, commercial collection side. But as I know a lot of bankruptcy attorneys on the debtor side, and they are getting calls like crazy. But there are also cases that aren't really ready to be filed because it doesn't make sense for the individual yet. They're kind
Well,
of
there's no court. It doesn't hurt that there's no court.
Yeah.
That doesn't help us any at all.
Yeah, the bankruptcy court's still reasonably functioning compared to state court, but yeah, no, it is true.
It's hard to operate when you're in court. Well, geez, this has been really super helpful, and we thank you so very much. If you were in our office, we'd have a bottle of wine for each of you, but unfortunately, we're not in our office, so we'll have to figure that out. Abby will have a game plan for that. Anybody have any last questions before we finish this portion? Jim, Alessia, anybody? Jean? Tim? Nope. Okay. Well, Marisol, Margot, thank you so much for your help. This has been really, really wonderful and really insightful and super helpful for our team. And we look forward to sharing. And if you want an update, Marisol, from Jamie on a monthly basis, I think she'd be happy to.
Yes, please.
Yeah, we can do that.
To send you and Margaret. And Margaret, do you want that too? To see?
Oh, yeah, that would be great.
We can give you sort of that heartbeat, at least for the next few months. Well, and she just did a summary. Jamie just did a 5-month summary, I believe. She just did a 5-month summary, so she can show you what the percentages are, who paid and who didn't pay, and so forth. So you can actually, that might be helpful too. Yeah. So do you have their email, Jamie?
I don't think I do, but I'm sure I can get it from you.
Okay, Abby will send it over. Okay, cool. Thanks, guys.
Thank you.
Take care. See you. We
Have a
appreciate it
great
very
day.
much.
Okay, bye-bye.
Take care. Bye-bye.